SJC-12741, Citrix Systems, Inc., v. Commissioner of Revenue.
Joining. Yeah. 7 stretch. Hopefully it's not the fourth inning stretch.
Mr. Fleming, good morning, still.
May it please the Court, Mark Fleming, together with Matthew Schnall and Elizabeth Bewley on behalf of Citrix. This is a sales tax case, and what matters is the definition of sale. The statute tells us what that is. Chapter 64H, Section 1 defines a sale in relevant part as a transfer of title or possession or both for a consideration. And both this court and the board have said that a transfer of possession turns on whether the purchaser has taken control of the property.
But here's the thing. Don't you have this problem with your regulation? I mean, the Commonwealth is basically taking the position that, the regulation answers all your questions.
So we don't think we have a problem there at all, Justice Lenk, for a number of reasons. First of all, the regulation has to be interpreted in light of the statute.
Why?
And, well, this court said in the...
Why is that?
If I may.
You never challenged the validity of the statute.
We don't challenge its validity. We
So
challenge...
you're saying that the only interpretation that makes sense is your interpretation of it.
That is correct, Your Honor. That we don't challenge its validity.
The Commonwealth's interpretation would make it invalid?
The Commonwealth's interpretation would, which is a reason to reject it, as this court said in the
But you have
Oliver...
not raised this issue of the invalidity of the statute.
We don't need to raise the invalidity of the statute in order to argue that it...
The regulation, excuse me.
I apologize, I repeated it, but we do not need to raise the invalidity of the regulation in order to argue that it be properly interpreted in line with the statute under which it was promulgated. This court said...
Tell me how you interpret it that's so in keeping with the statute.
So, the regulation on its face is no broader than the statute. It does not redefine the definition of sale. The definition of sale is set forth in Section 1 of the statute. This regulation does not purport to redefine it in any way, neither does the 2005 amendment under which the regulation was promulgated. Just like the statute, it merely says that for software, the method of delivery in the course of a sale doesn't matter. That's why it refers to, quote, sales effected in any of the following ways regardless of the method of delivery, which is...
I'd like to start the sentence says, taxable transfers of pre-written software include transfers of rights to use software installed on a remote server.
Well, Your Honor has omitted the language that we think is critical, as the government does as well.
Can't read it that way?
No, I don't think so. I think sales effected in any of the following ways is critical because it presumes, as the statute does, the existence of a sale. And a sale is defined as a transfer of title or possession. You can't take the word sale out of the statute. You also can't take it out of the regulation. Had the agency tried to promulgate a regulation that did not include the concept of a sale, that would have been invalid and we would have challenged it as such. But they did not write that. And
it says generally charges for the access or use of software on a remote server is subject to tax. What do you do with that one?
well, they're generally, I mean, that's true if they are sales in Massachusetts. I think you might hear the counsel for the Commonwealth say...
Access or use of software on a remote server are subject to tax.
Well, the access to use is talking about one of the types of sales that can be subject to tax. When the commissioner itself interpreted this language in the Cloud Computing Letter Ruling 12-8, here's what they said about it. They took our position. They said, using industry terminology, the access to software described in the preceding sentence, which is the sentence Your Honor read, is a virtual download of the pre-written software. The customer acquires the same functionality as if the software was actually downloaded to the customer's hardware. If you're getting the same thing from an online server as you would have gotten if you got the software on a CD-ROM or on a hard drive, that's a virtual download. It's a sale. That's not what happens with the Citrix software.
What happens with the Citrix software?
What happens with the Citrix software is there is a server software running on Citrix's computers. The parties stipulated, there's not only is it undisputed, it is stipulated by the government that the server software is under Citrix's control at all times, as is the dedicated network hardware that is necessary to create the connections that people come to Citrix to get using these online offerings. So this is not a situation where, as in, say, the TurboTax example, you could either get software for loading onto your computer on a CD-ROM, or you could download it from a website, or you could access it on a remote server. This is server software that can only work on Citrix's computers. Even if Citrix were to send a CD-ROM to you, which it doesn't do, it would never do, the connections would still not be created. This isn't like Skype, where there could be some kind of peer-to-peer connection between one computer and another one. You have to go through Citrix's network hardware and use the server software operating on Citrix's computers, servers, routers, and switches. Otherwise, it won't work. And this is not a factual assertion that I'm making. This is a finding the board made, that the online offerings require not only the operation of the server software, but also the network hardware. Both are kept solely under Citrix's control that is stipulated.
Will you agree with me that this case involves transfers of rights to use software installed on a remote server?
Ultimately, that is not the answer to the ultimate question, because there would still have to be a sale in order for it to
I
be
understand
taxable.
that. I'm saying, do you think that would you describe yours as software installed on a remote server?
I mean, the server software is certainly installed on Citrix's servers. I don't think I would agree it's a transfer of rights. But even if it is, that wouldn't end the matter.
To access and use?
Access and use the services, which is what we say in the subscription agreements on page 29 and 30.
That's not dispositive of what you say it is.
Well, the board certainly did not suggest otherwise. The board made a finding that not only do we refer to it in the agreements that way, we refer to it that way in our marketing materials and in our disclosures to the Securities and Exchange Commission. The only testimony on this was from Mr. Kanwar, Citrix's Vice President of Technical Operations. He was not cross-examined on this. There was no contrary evidence, and the board did not make any finding that what he said or what's in the documents in any ways lacked credibility. This court said in the New Boston Garden case a few years ago that the board cannot reject unrebutted testimony without a basis for some rejection in the record. It may not be disbelieved without an explicit and objectively adequate reason.
But
And
the
here,
mere-
I'm sorry, Chief
But the
Justice
mere
Gant.
fact that you call it a service doesn't necessarily make it so.
Well, if the board was going to make a finding as a matter of fact, supported by substantial evidence, that what the individuals, the customers were seeking when they come to Citrix was not a service, but simply to acquire the software, it was incumbent and required for it to explain what evidence it was relying on. And this is a stark case.
Did. I mean, its argument, as I understand it, and Mr. Cray will correct me in due time, is that it basically says that the regulation provides that a sale is affected by the transfer of rights to use software installed on a remote server. And as I understand it, what they're saying is that if somebody wants to go to if somebody wants to go to meeting or whatever else, then they purchase the right to use the GoToMeeting software, which was installed on the Citrix server, and that the use of that software in order to accomplish that purpose constitutes essentially a sale. I mean, that's my understanding of their argument.
That last part is certainly not something I think the board ever found. The board never tried to situate its findings within the context of the statutory requirement of the sale, which is the fundamental problem and where I'd like to go if I may.
But aren't they saying that you're focusing on the words sales affected, and I think they're saying a sale is affected by the transfer of a right to use software installed on a remote server. Is that not?
It could not be interpreted that way and be consistent with the statute. The statute says a sale requires a transfer of possession. This court and the board itself in the New York Times case said a transfer of possession happens when there is a transfer of control. It is stipulated there is never a transfer of control over the server software. I mean, we know that from the Mass Fine Wines case this court decided just a few months ago, the regulation has to be interpreted in line and consistent with the legislative design. So the statute is certainly relevant.
But that case also said, and I happen to have written it,
I know.
that it says that you must give every reasonable interpretation. You must treat a regulation as a statute, and that it is not to be declared ultra-virus unless there is no reasonable interpretation of it.
I want to be very clear, Chief Justice Gants. We are not saying that the regulation is ultra-vires. We are saying the regulation needs to be interpreted in line with not only its own language, but also the statutory language and the prior interpretations that the agency itself has given to the regulation after 2005 and 2006.
But again, maybe we're not sure we're quibbling because it seems to matter. I understand that to the extent that I read the statute that says that, or if the regulation were to say, as I believe it does, that a sale is affected by the transfer of rights to use software installed on a remote server, your view was that that is incompatible and inconsistent with the statute.
So I don't want to quibble either, but I want to be very clear. This regulation does not say a sale is affected by. It says
But it does
a
say,
transfer.
it does say taxable transfers of pre-written software include sales affected in the following ways.
Correct.
Transfers of rights to use software. I mean, you're parsing that pretty thin, aren't you?
Well, I don't think so, Justice Kafker, because I think what it does is what regulation is doing correctly is it is modifying and defining the category of the following characteristics that are sales. It could easily have left out sales affected. If it meant what the government says it means, they would not have said sales affected in any of the following ways. The reason they said it is because the 2005 amendment did not change the requirement of a sale. The statute is plain what a sale means. The statute is plain that a sale is required in order to have the sales tax apply. Otherwise, if they had left this language out, such that the implication of your question and the Chief Justice's question was that any time you have a transfer of rights, that is automatically subject to the sales tax. That would have been invalid, and it would have been challenged as such as contrary to the statute. We didn't need to do that because that is not what the agency did. And when the agency interpreted its own regulation
So
and the statute,
everything works. The transfer language works for the use. Tangible personal property is covered. It's just the sale. They had a transfer possession in your.
correct, because you can transfer
That's the
things.
missing step in this thing.
Yes, absolutely, Justice Kafker, because you can transfer things and not have a sale. The New York Times case is an example. The New York Times transferred an aircraft to another company to manage it and fly
But
it.
do
That
it
was not a sale.
in the world we're dealing with, which is software.
Sure.
And also in a world where everything is moving. I mean, floppy disks are going the way of the dodo bird, right? So that's, we're not going to give out disks. We're going to transfer the use electronically. So I'm just trying to understand what has to happen is they have to give you some kind of fundamental control over the actual software. Is that what you're saying?
Yes, that's right. And that can be done through a download. It can also be done through as the agency said, these are their words.
Even though they're giving you this, I'm not sure what the thing is I've used it, all of us have used that Citrix thing that's on our computers.
Just to be clear, there are multiple different Citrix products,
Yeah.
and a good number of them are software. They are sold as
You have
software, and we
to
pay tax on them.
But they've
These
given
particular
you
ones are
that,
different.
they've given you that item for your computer, and that distinguishes this from Westlaw and other things, doesn't it?
No, it does not, Justice Kaffer. I also want to be very clear. The product that you use or that the court uses may be different. Unless you use GoToMeeting, GoToMyPC, or GoToAssist, those are different.
Okay.
About 80% of Citrix's revenue is from sales of software, and we pay tax on those. That's not an issue
Okay,
here.
so what,
These are
that
separate
item
products.
that you put, that in this case, not the one I'm familiar with, but in this case, that is downloaded to your personal computer, that you have control over, right?
So
You can
what
do
is-
whatever you want to that thing, right?
The thing that I believe Your Honor is talking about is the endpoint software app, and that is something that you download. Anyone can download it. It is free. It can be downloaded by customers and non-customers alike.
It's free, but it's the key that opens up the thing that actually is useful. Without it, it may be free, but you're paying for the other service or tangible property. And without the thing on your computer, you have no, it's like, it opens the sesame, right?
Well, there's a couple of things to that. It does that in the sense that when you go to Burger King to buy a Coke, you need to get a cup in order to get your Coke. But nobody goes to Burger King to get cups. They go there to get the drink. In the same way, yes, it is necessary in order to participate in a meeting or to get the GoToAssist technical support, you need to have this app in order for your system to be able to talk to
But in your-
Citrix's
in your
server
Burger
software.
King
AG
analogy.
says that's an alternative grounds, too.
The board did not rely on that, and for, I'm
It's,
sorry.
well, they say that it makes it essential to get use out of the product.
Well, that,
So therefore, it's more of a sale, a transfer and possession than it is a service.
so Justice Lowy, this court has never adopted a necessary test. It adopts a basic purpose, fundamental purpose, objective of the transaction test when there is a blended transaction involving property and services. And that's for good reason, because if you have a blended transaction, the property is almost always going to be necessary. That's not the question. The question is, what is the customer actually buying? And in this case, nobody goes to Citrix saying, I really want this little endpoint server to sit on my laptop. They go saying, I want to connect to the remote computer, whether it's hosting a meeting or a tech support person. And in order to do that, you need far more than the little endpoint software app that's sitting on your machine. You need the server software that is sitting on the multiple servers that Citrix maintains in its possession, the thousands of servers and routers and switches worldwide that make sure that the call actually works. If what you had was your little server, your little endpoint module sitting on your computer, it would be like going to Burger King and getting a French fry container with nothing in it or a cup with no soda in it. And that is not what customers are coming for.
But they don't give you French fries and Coca-Cola if you come with your own cup. Yeah, you know, I'm just not sure that analogy makes any sense. Because
Well-
the way you get the Coke is in your case, you buy the Coke, but you know, they don't let you put the Coke in without, I don't know, the cup.
I use it, Justice Kafker, I don't mean to belabor it. I use it as an analogy.
Can I ask about inconsistent treatment? Because I'm trying to understand, we've got you know, technology is constantly advancing. Are they treating like services in your world differently? Sometimes treating something like what you do as a service and sometimes not? Or are they very consistent?
No, they're completely inconsistent,
Okay, so give
Justice
me an
Kafker.
example of software like yours where they treat it as a service. Because I read that footnote in your brief, and I'm not sure it's the same stuff.
So
because-
letter ruling 11-4 was a product that generated reports automatically about job applicants and then spat out reports, provided them to the customer. It was all done through software.
But my understanding of and I read that footnote carefully because I was very interested in it. So I thought those are access to information like Westlaw. There's not this object being put on your computer that allows you to manipulate the computer system. It's giving you access to this body of information out there like Westlaw or Lexis or something else. What you've got is allowing you to, this software allows the computers to speak to each other. It
doesn't, so I want to be I'm very clear, so I don't want to be perceived as conceding something in Your Honor's question.
Don't concede
There is no
anything.
ability to manipulate.
I have no doubt you're not going to be conceding too much.
I just want to be very careful. There is no ability to manipulate anything on Citrix's server software just because you have the endpoint software on your
What
computer.
it allows you to do is what you download, the whole system is a software device that's having these computers speak to each other, right? It's not providing you some kind of data like when I go to Westlaw or I go to my music site and it suddenly downloads music, right? This is a object that's sole purpose is to work the computers somehow.
So the endpoint software downloaded onto the computer does not do any of that work.
All of them
It allows you
together.
to connect to everything.
Together do that, which
Well-
makes it different than the stuff in your footnote, which allows you to get information or music, or if you're a golfer, the radar app, you know.
I don't think that's right, Your Honor. I think if you
Okay.
take the cloud computing example, which I believe is 12-8, I mean, there you have someone, you have the company has all the servers and they're providing storage in the cloud, not on your computer.
Right.
And you get to decide, it's all done through software, what you want to put into the cloud. And it's all done
But
through software.
it's not accessing information outside of it, it's giving you a storage, a computer storage thing.
Absolutely, just like what Citrix is doing. It's not providing information.
That one
It's-
should be, in your view, that's just what you're doing.
Yes, absolutely. And the commissioner said, even though it's done through software, It is not taxable. It is a service because the software is not directed or operated or controlled by the customer. It is consistently operated by the company.
But
Same thing with the...
delivery, but delivery is different. The sale might mean something else when you're delivering software on a remote server. And maybe the way this works is that when you're possessing access to a remote server and this software, maybe that's different than what happens at Burger King when we're trying to understand what these terms mean: sale, delivery, title, all of that.
So the legislature has told us what sale means. It means a transfer of title or possession. This court has interpreted what that means in the Browning...
context of software being quote-unquote delivered on a remote server?
When they amended the statute in 2005, they could have changed the definition of sale. They did not do that. This is why tax statutes in particular are construed strictly. If the legislature wanted to change the meaning of sale for software purposes, it could have done it. It could still do it tomorrow.
And you can also say that tax statutes are interpreted to the benefit of the taxpayer. I mean, there's all sorts of ties that go to the runner when you're dealing with statutory interpretation.
We cite both of them, but I think construing the statute strictly is the one that has the most bite here.
Are we supposed to be construing the statute, though, at all? Aren't we supposed to just be taking the regulation?
No, Your Honor. The
How do
statute,
you get to the statute if the regulation is there?
because the statute is the one that defines what a sale is. The regulation
I'm
does not.
challenging the regulation.
I don't need to challenge the regulation in order to ask that it be interpreted in accordance with the statute, which is clear.
You're saying you're saying that whatever delegation there might have been as to the meaning of the regulation, this regulation is beyond that.
No, I'm saying the regulation should be interpreted according to its text, according to the way the agency itself interpreted it after it was promulgated in letter rulings like the ones we've cited and that I was discussing with Justice Kafker. And that is a perfectly fair and, in fact, the most reasonable interpretation of the text of the regulation, which makes it consistent with the statute, because neither the statute nor the regulation changed the meaning of a sale. And that is a perfectly consistent way to read both the legislation and the statute and the agency's own prior decisions. If the regulation was really trying to change the meaning of sale that has persisted in the Commonwealth since 1966, one would have expected it to say so clearly. They didn't say so clearly. The legislation leaves sale where it is. All that the regulation and the legislation are doing, and this is admitted on page 14 of the red brief, the board itself found it, was to change a regime under which software provided on a tangible item was taxable, but software downloaded electronically was not. That distinction was done away with. There's no dispute about that.
Can I ask
but
about-
now what we're dealing with, I apologize.
Now, can I ask about, Mr. Cray's, one of his arguments is, all you're going to do is, if you win, you'll just become a use tax. What's your response to that?
I think it's a curious argument in light of the stipulation that the parties reached on page 50 of page 50 of volume 1 of the appendix, paragraph 108. The parties stipulated that if the sales of the online offerings are not sales of tangible personal property, then the parties agree that those sales were sales of services not subject to Massachusetts sales or use tax. And all the sales tax should be abated, and that makes sense because generally, if you're exempt from the sales tax, you're also exempt from the use tax. Besides, a use tax also requires control. The statute, Chapter 64I, Section 1, which governs the use tax, talks about the exercise of any right or power incident to ownership of the property. So the inquiry, we think, is exactly the same. And here, evidence matters. We didn't put in evidence of the type of control that Citrix has over the server software or the hardware because the Commonwealth stipulated to it. That is the exact reason why there was a stipulation, to avoid the need to create a record on it, which is why the board never denies that Citrix maintains control for purposes of this court's decision in Browning-Ferris or for purposes of the board's decision in New York Times. And because there is a preservation of control in Citrix over the server software and the hardware, there cannot be a transfer of possession or title. There is no sale and no sales tax.
Can I please ask one last question, Chief?
I'm here for the court, obviously.
As long as the Commonwealth's, that is to say the board's and the commissioner's construction of the statute isn't totally unreasonable, don't we have to defer to that?
Well, I suppose theoretically, yes. But the assumption behind the question, first of all, the assumption behind the question, I believe, is that the regulation purports to construe sale. It doesn't do that.
It purports to, it does not? You don't
No, it
think?
does not. It does not construe sale at all. It simply says that if you have a sale, it does not matter what the method of delivery of the software is. That's all it does. But in order for it to apply, just like the statute,
You think that's the way the commission is construing its own regulation?
it was in the prior letter rulings, absolutely, in the ones about the cloud compute. Well, no, its litigation position, no, it's taking a very different position now. But we think because it is inconsistent with its prior decisions, that's another reason no deference is due. It's contrary to a clear statutory mandate, and it is contrary to the long-standing principle that to the extent there's ambiguity, remember, agency deference only comes in if the statute is ambiguous. If the statute is clear, then it's construed as a matter of law de novo by this court, which we think is the right thing to do because the definition of sale is clear. But if it's ambiguous, then you fall into the canon that a statute that defines the scope of a tax, which this one does, and the Ohio statute the government would like to put in front of you does not, if it defines the scope of a tax, the legislature has an obligation to speak clearly. It's well aware of that obligation, and it should be construed strictly, that the sale still persists, the requirement of a transfer of control still persists, and to the extent the government is arguing that there's an ambiguity, that simply puts it into the canon of strict construction, not into deference where the argument that they are presenting is contrary to what they've said in every other letter ruling that they've cited, and they have never even attempted to reconcile those letter rulings with the litigation position they've advanced in this case.
Chief, could I ask one last question? If they transferred a license, right? If they transferred a license to use this software, would that have been a transfer that a sale affected if they'd made you pay for a license, if they just used the word license? Because maybe my knowledge of software is dated, but in the old days, you got licensed to do things.
And this is, again, why I think the evidence matters. It would depend what the license was for, what it...
License was a license to use the software, and you paid for it.
Well, again, I think it depends whether the function... No, I'm sorry, I'm not trying to...
Help me out.
I'm not, yes, thank you. I'm not trying to fight the question. I think I'll answer it. Let me answer it this way. Looking back at the ruling, the cloud computer ruling 12-8, if the license gave the user the same functionality as she would have if the software were downloaded to her computer or provided on a CD-ROM or on a hard drive, then I think that would be a sale because it's a virtual download. You're giving them the same thing as they would have if you sent them a CD with the software on it.
All I'm doing is changing this from a contract that uses the word exact same everything, but it just, you pay for a license. It's a license, because that's a property right, a license. You've been given a license to use this. Would that meet this definition if they just use, because I noticed the word transfer in the statute doesn't use the word license. It talks about leases and other things. But would a license be sufficient? All the facts exactly the same?
Okay, that's an important aspect of the question. If all the facts are exactly the same, the fact that it's referred to as a license, I don't think makes a difference. What matters is the functionality. If the customer is getting the same thing they'd be getting as if they'd gotten a CD-ROM in the mail, then that is a service. You're just, that's a sale of property. You're just giving them what they would have gotten had you sent it to them in hard form. But that's not what happens here. You couldn't send someone the Citrix server software and expect it to work on a home computer. It does not function. You need the server software running on the thousands of servers and switches and routers that Citrix maintains. That's the only way this is going to function. I thank the court for its attention. We respectfully submit the judgment, the decision of the board should be reversed.
Thank you. Mr. Cray.
Thank you, Your Honor. Excuse me. May it please the court, Pierce Cray, Assistant Attorney General for the Commissioner of Revenue. On the issue of whether or not the statutory definition of sale is satisfied, Citrix's argument is almost entirely premised on there not being a transfer of possession of software. But we believe that's not the case here. There's no dispute that one component of the broader transaction is a download or other installation into the buyer's own computer of this endpoint software that was found to be necessary to the transaction. Citrix has never disputed that a download is not itself a transfer of possession.
That they downloaded this, in fact. You're saying it's a virtual download, aren't you?
No, there was one aspect of it that is a true traditional download in which that part of the program goes from the seller's computer down into the buyer's computer. The record indicates other times it could be installed into the computer, perhaps by a technician coming or putting in. But it is the endpoint software does have a different quality than the server software. The endpoint software is in the person's computer. They've never disputed that the buyer doesn't control that software. And under their whole theory that you have to have control to have possession, that would be possession. And the most basic way to resolve this without getting into all the additional issues about the status of the remote server software is just that you look at the transaction as a coherent whole. The downloaded endpoint software, you can't get anything else unless you have it. It's necessary to the transaction, it's integral to the transaction, so you look at the transaction as a whole.
Is Adobe a sale that allows me to read PDFs and edit them?
First, Your Honor, I can't comment on individual companies. There's a specific statute saying we're not supposed to.
Right,
So.
something similar to a PDF viewer. Would that be a sale?
You know, that actual
That pops up every
technology, I
5
could
minutes and
submit
asks me to download it again?
I can hit cloud computing, cloud storage, internet auction, but Adobe I'm not familiar enough with the technology or how that works. Excuse me, I shouldn't even have referenced the name.
Okay.
But that,
All right,
that
my bad. I
mode of
caused you
vehicle.
to.
But let's just see, going back to the initial question, is the threshold definition of sale in the statute, 64H, Section 1, is it met? There is nothing in the definition that says you can't look at a transaction as a coherent, integrated whole and consider all the components that are necessary to it, that are integral to it.
So is that the critical component, that you download something onto your own computer? Is that what distinguishes it from, example, this drop? Okay, I'm using what's in the footnote. They've got examples of items that are in the footnote. Is this distinguishable from those just because you download something onto your computer? How about that, the cloud storage?
Just let me respond to this, Your Honor. If you're only
I'm worried about consistency, because
No, I appreciate that. And when I get to the argument of how do you distinguish a service from a sale, that's absolutely, I can provide I just want to make clear there is a sale in the first instance. And the reason why there is a sale in the first instance, the simplest way, you look at it as a coherent whole. That's consistent with the traditional doctrine that in tax matters, the court looks to substance, not form. You don't let the vendor slice and dice it into different components and say that way they get out. You look at what the real world functionality is, and to be able to get the functionality is you have to, for this taxpayer, have a download. That's enough to be a transfer. I'm sorry, Your Honor. Go ahead.
I think they have a narrower view of the legislative intent here and what the legislature was seeking to accomplish. That they're just trying to deal with tax treatment when software is sold in a conventional way. You know, you sell software in a conventional way now, much differently than you did with floppies and everything else. And that I think their view is that you got to look at the legislative intent a lot more narrowly, and that's where a lot of the arguments come from.
Certainly are. Their narrower view is that when the statute was amended in 2005, it did say that electronic transmission is sufficiently tangible or physical to be tangible, but it did not eliminate the requirement of a transfer of, not just a transfer, but one of possession and control. That's their narrower view of the statute. We're saying even take that as it is, under that narrower view, these particular transactions still satisfy it, because an integral component is the downloading of software, which they've never disputed, is itself a transfer of control and is something you possess. You do possess the programs that are installed inside your own computer.
I'm just trying to figure out what that means. So when I download an app, is that what you're talking about? I mean, like if I downloaded any app that, I have that on my computer, right? I've paid for that. It's on my computer. Does that mean that we're now that's a sale?
You're a sale and you get to, if there was consideration exchanged, you will have a sale. There is a transfer by electronic is enough.
Right.
And it's a transfer of possession because it's a download that you get control of in your computer.
Right.
And just so I note, there is, if you view this.
And in those examples in that footnote, that doesn't happen? In footnote 4, where they go through a bunch of these different things, that doesn't happen in those?
It all depends on the facts of the different situations.
Well, walk me through the one he gave, because I thought that's the most interesting one, the storage. You've got this storage thing. Nothing is downloaded in your computer in that case?
If there were a download that would get you over, and that was a coherent part of it, of the integrated transaction, that would get you over was a sale in the first instance, is the technical terms of the definition of sale satellite. There would be the further question about whether or not it's a service as opposed to a sale. And here, what's really important, I want to emphasize, is there is a specific regulation that specifically addresses how you draw the line between a taxable sale and a non-taxable service. That's in 830 CMR, I apologize for the length of this, 64H.1.3, section 14A. And it sets out both a general rule and a specific exception, again, not addressing service versus sale generally, just as regards software. The general rule
Could I
is...
just for a second go back to what you were just saying about the use of the endpoint, the downloading of the endpoint? Isn't that sort of incidental to the transaction? And haven't you said that already in another context, like letter ruling 1211, that it's incidental?
No, it's
incidental.
It's in that was again addressing is it sale versus service as regards. Is it a sale in the first instance before you even get to drawing the line between sale and service?
Slender read, don't you think? Don't you think this is a pretty slender read in which to found your argument?
I'm sorry, Your Honor. What?
The slender read. Don't you think it's a slender read? This business of the endpoint.
I'm sorry. The endpoint is.
I mean, it's incidental to the nature of the transaction. It doesn't define the nature of the transaction.
So, for example, given Attorney Fleming's analogy with the Burger King cup.
Yes, sir.
What you're talking about is buying the cup, right? I mean, would you agree with that?
Buying the cup and the drink combined.
Well, but I thought the drink is in the servers and doing the work of the
But you're buying, when you go to Burger King, you buy them together. Here, too.
But you buy them together, but here we're talking about just the piece of the transaction that is the cup. I'm just trying to make sure I understand, because if that's the case, should we just be talking about considering taxing just that portion?
No, we're asking, that, Your Honor, that it be, you look at the transaction as a whole. In Burger King, both the cup and the drink that goes in it. Here, both the endpoint software and the server software that it accesses to. If you look at whether, but what we're saying is just as to that issue, do you have a sale in the first instance? Even accepting their argument that a transfer of possession is required, it's enough. I'm sorry, Your Honor.
The use of the software, the regulations, the examples that are given to us, the regulations with the tax software, is that what you were going to go to?
Yes, that again is in defining whether you draw the line between.
But the product, the product is the tax software that you own, that you manipulate to do one's taxes. What the taxpayer is saying is that they've only given you the key to the service, and all the go-to-meeting stuff is everything that's housed independent of the initial software that gives you the ability to log on.
Right, but both are at things that the buyer acquires in different capacities. To the extent transfer of possession is so critically important, which we dispute, but the extent it is, it's provided by the download component. I'm sorry, Aaron.
If I'm going to this vintage clothing example, right?
Yes, Your Honor.
I need to download the software that gives me the ability to bid on this stuff, right? So suppose there's some software that allows me to join these online bids. I have to download that, and then I bid on the product, right?
Yes, sir, and then you look to the terms of the standard in that regulation to decide, is it a service or is it a direct sale of a good? And the language, the basic rule is generally charges for the access or use of on a remote server are subject to tax. I believe in Your Honor's hypothetical, the internet auction buyer would not even be charged. So there's not going to be. When the internet auction buyer pays for an additional good, they're not being, even at that point, charged for the use of the software. Here, Citrix has made it easy. They have a contract that on its face imposes charges for the ability to subscribe and use software on their remote server.
Well, and now you're talking about that subsection 14, I think.
Yes, I absolutely am, Your Honor, and that's
the question. I mean, it has to be some money charged.
and there is, Your Honor, for the package as a whole. If you look at Volume 3, page 28 of the record, they're charging for that. So, and what they're charging for is the use of software on the remote server pages.
What about computer research?
Yeah.
Okay.
Take for example, East Law.
So, well, let's, okay. The same broader regulation, not 14A, 13A, specifically removes that from taxation. And indeed...
And why is that?
Well, conceptually, it is a service or good, a service that's separate from simply using the software. You're looking for all the data.
Is it, in your analogy, is it like you're being able to buy things on the auction? Is that it? Because it's not the product or the the tax software. It's that you're getting something else for it?
Yes, sir. And the key thing, Your Honor, is, again, we submit the terms of the regulation should be the beginning and the end of any inquiry.
Which regulations are you talking about?
14A
That's
is the one that defines the line in the computer context between what's taxable and what's a non-taxable service.
How does that work?
How it works is...
It is because you say it is? How is it connected to the statute?
Pardon?
How is it connected to the statute?
There actually isn't a general statutory rule on service versus taxable transaction. It's one that's been addressed in various contexts, sometimes under specific statutory exemptions that aren't relevant here. But here, because there is line drawing involved, the commissioner has promulgated a regulation. And the key thing under the regulation is if it's a charge for the use of software on a remote server, that's taxable. That's what it says in the first sentence of 14A.
That's what it says in the regulation, yes. Is the regulation tethered to the statute, the question is?
Pardon?
Is the regulation tethered to the statute, though?
Yes, it certainly is. But I would first say that on the issue of the regulations connection with the statute, we've put several arguments forth in our brief as to why it's fully can be concluded to be fully within what the statute commands. The one I want to stress, I think is the most straightforward, is that you have this unequivocal regulatory text. 4 times since the commissioner promulgated, the legislature amended and reenacted the statute without changing this language.
But it never uses, your opponent's argument is that it never uses, it just weaves to the definition of sale. It talks about transfers, but it doesn't, it leaves, I mean, there's a bridge that it doesn't cross to sale, right? it doesn't really directly address the sale
The
issue.
regulation certainly crossed that bridge.
Where does it cross it? Where does it use the word sale?
In 14A, it goes, they focus on subsection 3A of the regulation. We have a lot of arguments about that, but they're resolved by section 14A, which again just says, the commissioner is saying charges for the access or use of software on a remote server are subject to tax.
But then it says,
doesn't say
but
sale.
not, then it says, and this is what I guess, however, where there is no charge for the use of software and the object of the transaction. So is the charge for the software or is the charge for the service? And
What
you
it's
need
saying
this-
is
and
it-
you- let me just make sure I
I'm
get
sorry,
it out.
sorry, Your Honor.
No, because it's, I really don't, I don't know the answer to this question. Is the charge for the service they provide, and you need the software to access the service, or is the charge for the software?
It all depends on the facts. Here, it's very clear. If you look at pages 28 to 29 and 36 to 37 of Volume 3 of the record, that what they're charging for is the use of the software. There is effectively, in common law property terms, what would be viewed as a license. The language doesn't say that, but the court's prior decisions going back decades indicates that would be essentially a licensing type transaction. But the exception has two elements: no charge.
You notice the statute doesn't use the word license, though. Does that matter? It talks about lease, it talks about other things. It doesn't use the word license. I thought that was odd.
The statute doesn't, as amended in 2005. Directly in sales tax, it does over in the use tax, which we claim you need to interpret consistently. But what we think the easiest way out of this is that there is unequivocal regulatory language by the commissioner that these transactions, specifically what the terms of the Citrix agreement put before the court, are taxable, and that the legislature 4 times has reenacted the statute without changing that language. Under the court's Pavian decision, Chief Justice Marshall was very clear. The legislature is presumed to be aware of that authoritative administrative construction, and when it changes, amends the statute without changing that language, that is deemed to incorporate that authoritative administrative construction.
Could you address, though, the taxpayer's contention that if you read the regulation the way you want it read, it's in odds with the statute, and therefore it cannot stand?
We would claim that we've gone back and forth. My first response, Your Honor, is that if there were any dispute on that, it's resolved by the legislature's subsequent reenactment and thereby deemed incorporation of what the commissioner says. So you don't even have to get to what was intended back in 2005.
But let's say I do.
Pardon?
Let's say I want to go there.
Okay, if you want to look at it, we are, again, and our first response is that their position under the statute in 2005 is you have to have a transfer of possession. Our response is there is one as regards one component. You look at it as a coherent whole. That's looking at substance rather than form, not allowing a company to sort of technologically evolve itself out of taxation where something that clearly was taxable before becomes untaxable. That's directly where the substance form doctrine should come into play. But even if Your Honor solely wants to focus on the remote server part of the transaction and just assume there was no downloaded component, which is not the case, because there was. But even there, our view is that the amendment in 2005 to the definition of tangible personal property, which made clear that a electronic transmission of software was a transfer, the commissioner construed that as also implying that those transfers were taxable. He had a technical information release that came out 2 months after the enactment of the statute to that effect, and then he had the regulation that we've been discussing coming out to that effect. The board also viewed that as a reasonable inference from the 2005 amendment, that it addressed not just tangibility but also taxability. And most importantly, in our view, when you look at the interplay with the use tax, once you get rid of the question of whether or not a electronic transmission is tangible, which even Mr. Fleming concedes this amendment affected, you go to the terms of the use tax. Use tax deals with purchase, and definition of purchase does include a license to use, where we would say. Now, the stipulation that Mr. Fleming referred to, I'll be honest, that wasn't in the reply brief. I would construe that stipulation as not going to legal argument for how statute should be construed.
I missed that. What did you say? What was that last piece?
There was a stipulation.
What stipulation are you referring to?
I'm sorry?
Which one are you referring to?
Which stipulation?
Yes.
It was, his citation was to volume 1, page 50 of the record. And it is, if you read, the stipulation reads, if sales of the online offerings are not sales of tangible personal property, then the parties agree that those sales were sales of services not subject to Massachusetts sales or use tax, and all of the tax at issue should be abated. That stipulation goes to the service, what's a non-taxable service and what isn't. I don't read that stipulation as going to whether or not you have a sale or a use in the first instance. So it sort of goes to the second of their major arguments, but not to the first. So I think it is fully appropriate for us to be arguing the interplay between the use tax and the sales tax. And again, our basic point on that is that clearly these transactions would be subject to the use tax, and that would just put them out of the frying pan and into the fire. So it makes much more sense simply to construe the definition of sale as implying taxability in the first instance, rather than having that circuitous back and forth.
If your discussion of the endpoint software, I'm not sure, has helped me to understand. Let's assume that Citrix finds a way that there's no need to download the endpoint software and says you can give a temporary PIN to whoever wants to use it, and there's no need now for you to download anything. Does that change your position?
No, Your Honor, because that would, it makes it, it doesn't give the very easy answer that I had with the endpoint software. But if the hypothetical is no endpoint software, just the ability, the right, contracted for right to use server software, remote server software, then that would fall directly under the terms of the regulation, which was addressing essentially that hypothetical, just remote access software in isolation. And again, you had the legislature 4 times reenacting.
I got that point.
So
Section
is that
14,
responsive?
Section
Sorry.
14 versus Section 3. There was the Appellate Tax Board focused mostly on Section 3. But let me, am I correct that you're saying that Section 3 says that a sale is affected by a transfer of rights to use software installed on a remote server, and that Section 14 essentially says the same thing?
Yes, more explicitly, more directly, it's an independent source of our position. It also would resolve any ambiguity raised by all of Citrix's arguments about 3A, but so it confirms our interpretation of 3A. We feel that in and of itself provides that, that at least in the regulations terms, that these remote server rights, giving them the right to use the remote server, that is a sale. But even if one were to say Mr. Fleming's put that into play, it's certainly resolved by the unequivocal language in 14A. So the regs are clear. We feel that And additionally, where the regs are clear, the court in Baybank has, Justice Reed there did indicate the fair thing to do is if you don't like the regs, challenge them directly, deal with all the presumptions and burdens that come with challenging directly, and don't engage in what Justice Reed called a backdoor challenge to the.
But their position is it's not a backdoor challenge. Their position is, doesn't matter how many times the legislature's dealt with this section in the past, they didn't provide any change to the definition of sale, and that sale requires a transfer of title of possession. So the regs really are divorced from the statute.
That's their argument, but in the Baybank case, the indication was you don't go and look at the underlying statute unless you bring a direct challenge to the regulation. Their attempt to distinguish that, the only response they had was that this was a so-called, this regulation was an interpretive regulation, while the one in Baybank was a legislative one. That does refer to a distinction under federal administrative law. It does not exist under Massachusetts administrative law. And I'd specifically cite the court, this is not in my brief because it was only brought up in the reply, to the Purity Supreme case, which is, correct me, it's 380 Mass 762. All regulations are deemed to have force and effect of law in Massachusetts. And so we would view the Baybank's approach in which if you want to challenge a regulation, go at it, face it straight on and make a direct challenge, that is gives an appropriate amount of respect to the executive branch as a co-equal branch of government and is the approach that should be taken.
I understand their position to be that they don't need to do that because if it's properly construed, there's no problem.
Pardon?
I said I take their position to be properly construed. There is no problem with this regulation, so they're not challenging it as being ultra-virus.
Well, they're doing it by what I think Baybank fairly described as a backdoor way. You always can say, well, I'm not challenging, I'm just interpreting it, and get all the same arguments out without having to deal with the burdens that accompany that. So that's our, I will be honest that there are, I've acknowledged in our brief, there are other decisions of the court that have not considered the Baybank framework and have construed looked at the statute when construing a regulation. We're saying that Baybank did have a good, a sensible approach that did respect the co-equal branch, and it is something the court should reaffirm here.
All right, thank you.
Thank you, Your Honor.